For joining this afternoon. The heading to the seminar is Preparing for the End of Transition, Immigration Issues for Barristers. Of course, we are past the end of transition, but we're still trying to work out what the immigration position is for barristers going forward. And I think just a few introductory points. Obviously, well, I just say obviously, it seems that we have at least a deal. And had there been a no deal, that would have been quite difficult for building bridges and going forward. But a deal, however small, however minimalist, keeps doors open. The second thing I'd say, by way of introduction, is that the ability to give advice under your home country title on English law and international law has been preserved, subject to the possible need to register in certain member states. And it seems the view of the MOJ, or not people on this call, but the view of the MOJ has been expressed that the ability to go and represent people in arbitrations abroad has also been maintained. And so those are, for the bar, significant interests. For recognition of qualifications and for joining another member state profession, there is under the agreement a partnership council which permits there to be agreements between, say, the UK and the member states, or between regulators, so the BSB, for example, and the SRA, together with regulators from across the EU. And that is possible, but it would need, it seems, to have all member states coming on board for such a deal. And so the bigger question for the bar and also the Law Society is whether or not regulator to regulator bilateral deals are still possible. And we're obviously looking at that because we have more interest in certain jurisdictions than others. So that really brings us on to the question of visas and immigration and travel. The distinction, as Adrian and others will be explaining, between the business visitors and independent professionals routes. This seminar is aiming to clarify, at least so far as we know at present, whether and to what extent we are going to have immigration issues when we move to work in other member states, and that is either by fly in, fly out, or by something else. So in this seminar, we're going to have, first of all, an update on the key points of the deal from a combination of Kyrie Kyriakou from the Ministry of Justice, on the one hand, and from BEIS, we've got Zoe Bruce and Sam Raby, who will be together, the three of them will be giving an overview of the key points of the deal with the EU. Sam Raby and Zoe Bruce, they're policy advisors in EU Mode 4 Services, Department for Business, and Kyrie Kyriakou is head of Mobility, Migration, and Asia and Middle East Market Liberalization at MOJ. Then following the intervention from government, there will then be more detailed explanations from Adrian Berry from Garden Court Chambers, who's a specialist in immigration, and he will be clarifying some aspects of the different routes. Could I ask that anybody who has joined, I think the aim is that it will be speakers who have their videos on, and people joining the seminar just switch off their video and mute their microphones so that we have minimal interference. And if we do that, then we'll be able to see the speakers on screen. So without further ado, I'll pass over to our government colleagues, Mr. Kyriakou and his colleagues from BEIS. Thanks, Kyrie.
Thank you, Hugh, and thank you for everybody for joining us this evening. Just to briefly introduce myself, I'm Kyrie Kyriakou, Head of Mobility Policy at the Ministry of Justice. My colleague Zoe Bruce from the Department for Business, Energy and Industrial Strategy, and I have prepared a bit of a brief presentation this evening on short-term professional mobility and the EU. Following the agreement reached, of course, between the United Kingdom's government and the European Union late last month. What we'll do this evening is just take you through some of the key aspects and provisions of that deal as it relates to the legal sector and barristers in particular who would be travelling for a short-term basis for temporary service provision in the EU. And really just to kind of give you some of the points and pointers to look out for to help prepare yourselves before travel. We'll also finally briefly touch upon the inbound system for barristers seeking to enter the United Kingdom from abroad for work as well. So just to kick off this presentation this evening, Zoe, grateful if you could move on to the next slide, please. Thanks, Zoe. So yes, just to kick off, as you can see, that first slide sets out the key categories of short-term service supply as found in the agreement itself. You have really 6 main categories of short-term service provisions. The first 2 that we've highlighted there are essentially the ones of main interest to the bar, to barristers. The 2 that we have there are short-term business visitors and independent professionals. On short-term business visitors, essentially, as it says on the tin, short-term visits, short notice visits, usually for less than 90 days in a 180-day period. And for independent professionals, that's the route for self-employed business people, such as barristers, hired for services in another country. Zoe will cover those 2 in a little bit more detail shortly. But just for completeness, the other kind of 4 main routes that are part and parcel of the agreement include the Intercorporate Transferee route. This is where you are based in an office in the UK, for example, and you're transferred to a subsidiary branch office of that same company in a different country. Contractual service suppliers are generally business people who are carrying out contracts to supply a service to a client in a different country in which their employer has no previous presence, so very much focused on the employees rather than self-employed. Investors, if you're moving temporarily to invest for yourselves or on behalf of a company. And the final route there is the business visitor for establishment purposes route. So a business person temporarily visiting another country in order to get to set up a business or a firm. So those are really the 6 key categories of short-term service supply. And as I say, we'll try and focus a little bit more on those top 2 there. I will then now hand over to Zoe, who will take you through some of the detail behind those provisions.
Great, thank you, Kiri. Just to clarify, and apologies, this may be because of my slide editing, but I just wanted to make clear that the investors category is not included in the TCA between the UK and EU. It is a Mode 4 category of service supply and a typical one that is included in other free trade agreements, but in the TCA it's not. Obviously, it's still possible to move as an investor, but the provisions aren't included in the agreement. So moving on to the next slide. So in terms of what the deal actually does and what's included, what provisions are included, the commitments that have been agreed by the UK and EU they provide that guarantee of market access in a number of sectors for service providers and for business travellers. And it also guarantees a minimum standard for how they should be treated, when working abroad in the other party. So these minimum standards include, for example, eliminating nationality requirements for some roles and guaranteeing how long business travellers can stay in the EU. As Kiri mentioned, I'll be talking a little bit more about short-term business visitors and independent professionals, where I go into a bit more detail on that duration of stay. Provisions in the Mode 4 chapter will or do also decrease the administrative burdens for some business travellers. So, for example, they limit the need for economic needs tests and work permit requirements as well for some activities and sectors. The provisions also ensure that the UK and EU member states have transparent visa application processes, as well as clear signposting on rules for business travellers. So moving on to the key routes for barristers, as Kiri touched on at the start. So firstly, I'll discuss short-term business visitors. And as has already been said, the stay, and as is enshrined in the deal, is up to 90 days in 6 months. So the provisions are that no work permit or economic needs tests are required, although this is subject to reservations being taken by the parties of the agreement. Those reservations are made clear in the annex in the TCA, which is available on gov.uk. So while not enshrined in the deal, some STBV activities will also not require a visa, although we do advise that you check before travelling in terms of whether you need to get a work permit and or visa. So the conditions that are set out in the TCA are based on best precedent. So short-term business visitors can't sell goods or supply services to the general public. They can't provide services as part of a contract, and there can be no remuneration. So these are fairly standard provisions in free trade agreements. The activities that are permitted in the STBV list, which is, I think, on page 745, although I maybe should have checked that first, but is in Annex 7.3, include meetings and consultations, as well as commercial transactions. The full list is 11 activities, and on that slide you can see some others. So, for example, research and design, translation and interpretation. Just to note as well that the UK additionally operates an expanded list of activities that can be done on gov.uk. So you can see an example in red at the bottom there. So, for example, a short-term business visitor provision means that a barrister undertaking a short 4-day visit could meet a client in France. They'd be able to enter France without a work permit or other prior approval, but they would have to abide by all the other rules that are in the TCA. Just a quick note, I can see that someone's raised their hand. I think we're going to keep Q&A till the end, so if you do have a question, then if you can put it in the chat, but otherwise I'll wait till the end.
No, just to say, sorry, Sam here, Vase as well. I just want to say, like, it would be easier for us if we get questions typed in advance in the chat. Will allow us to answer them more fully when we get there. We can get to that after the slide's been presented. Thank you.
Great, thank you. So if we move on to the next slide, so this is the other category that Kiri was referring to, independent professionals. So this potentially is a slightly longer term route. So the stay is up to 12 months. Again, with STBVs, there are certain provisions and conditions. So you need to be self-employed. The service contract can't be for any more than 12 months. And the length of professional experience is specified as well. So you need 6 years of professional experience in that sector. You also need a university degree or equivalent as well. In terms of the relevant sectors that are included in the TCA, so you can see in Annex 7.4, which has a list of contractual service supplier and independent professional sectors that are included in the coverage, would be legal advisory services for public international law and home jurisdiction law. Again, I've included an example there. So for an IP, a barrister could provide advice to a client for 7 months. They would need to seek entry to Italy via Italy's independent professional route. But as hopefully will make clear throughout this presentation, that barrister would need to check the Italian immigration system for details on, for example, application process, visa, work permit, etc. So I'll move on to the next slide. In terms of what we advise business travellers need to do before they travel, we advise that you do these things in advance. So, for example, we advise that you need to check if you need a visa, a work permit, or other documentation. If you do need to apply for a visa or work permit, you'll need to do so ahead of time before you travel, and you'll also need to check that your passport is valid for at least 6 months before you travel. I'll move on to the next slide. So I've just gone through the rules very quickly of the Trading Cooperation Agreement. There are also additional rules, mobility rules, that are not included in the TCA that are included within what's called the Schengen visa waiver. So as I'm sure you all know, the Schengen area is a group of 26 European countries and essentially functions as a zone of free movement. Due to the UK's inclusion on the EU Schengen visa waiver list, certain activities are or should be permitted visa-free, as well as so for the STBV list in the TCA, this is work permit free. This Schengen visa waiver list sets out some examples of things that can be done visa-free across the whole Schengen area, and this is for up to 90 days in a 180-day period. So in terms of what can be done, it includes business meetings, attending conferences, receiving training, sporting and cultural events, and tourism as well. On top of that, some member states also allow additional short-term activities that don't require a visa as part of their own domestic immigration regimes. As I've mentioned before, we do advise you check the individual immigration regime of the country or countries you are planning to visit, as the rules could or probably will differ by country. If you plan to stay longer than 90 and 180 days, or if you're planning to do anything that is not included in the visa waiver list, then you may need a visa or a work permit and or other documentation. As Kiri said, we thought it might be helpful to include some information on inbound movement. I am from Bays, so I'm not a Home Office person, so I can't give you too much detail, but these next two slides kind of explain the categories that you can visit via the UK's system. So as visitors, you can either apply for a visa before arrival or seek leave to enter at the UK border. The government has made clear that EU and Swiss citizens do not require a visa to visit the UK. So this is, you can find this on gov.uk. The list of activities that visitors can do is for up to 6 months, and you can enter the UK multiple times. And these activities are much more expansive than the list in the TCA. So, for example, you can attend meetings and conferences, but you can also carry out independent research, undertake work-related training, etc. If you search for this on gov.uk, you will find a long list. As well as that route, there's the intra-company transfer route. So as Kerry mentioned right at the very start, the ICT route is for workers who are being transferred by the business they work to a different branch of the same firm. There are various eligibility requirements, and the obvious change in 2021 will be that EU citizens will need to use these routes, which will require visas under the points-based system. Moving on to the last slide, I appreciate this is very small writing, so I think we can probably share this afterwards, but there's a couple more worker routes. So for example, the Tier 5 visa route has a couple of subsets So there's the temporary worker, the international agreement worker visa. So this route is for a person who wants to provide a service covered under international law. This includes providing a service under contract as either a contractual service supplier or as an independent professional, which I mentioned previously. So a person on this route can stay for a maximum period of between 6 months and 2 years, and that depends on the international agreement. There's also a government authorised exchange visa, and there are 2 schemes within this run by the Law Society of England and Wales and the Bar Council. And for this, the stay is for a period of no more than 12 or 24 months. And then the last route that I've got here is the skilled worker route, and this is the sponsored route. And as you've probably read, there are requirements in terms of salary thresholds, as well as skill levels and points for an approved sponsor as well. I won't go into too much detail there because that is EU to UK, but we should be able to share those slides afterwards. They've just been taken down, so I assume, and that wasn't me, so apologies for that. That's the end of our presentation, and so I will pass back to Hugh. Thank you, and we can take questions at the end.
Yeah, thanks very much indeed, Zoe. That's really helpful. And for the slides, I've just been contacting Kiri whilst you've been talking, and I think what we'll do, we've got your slides on the one hand, and we've also got a note from Adrian, which are both coming together. And I think that the position is that if we can send those to participants, anybody who's registered with the seminar during the course of next week, that'll give time for a little bit of review and checking. But I think that was very helpful because particularly the last slide was quite small writing and quite detailed. But I mean, generally, you know, some of those examples in red, I found them quite helpful. But we'll see, obviously, whether Adrian has any comments. Somebody, in fact, couldn't see the slides for some reason, but anyway, so that they will get the slides during the course of next week. So if I can then move on then. So thanks very much indeed from the government side, and also thanks for the work that you've done in contributing towards an agreement, even if obviously it's rather different to being an EU member. But anyway, that was always the result, going to be the result of leaving. So Adrian, I think it's over to you to elucidate some of the finer points of those points useful for barristers. I was particularly interested by the first of those red points in the PowerPoint we've just seen, when it said that you could see a client in Paris, don't take payment whilst you're there, and that's fine. But I think that obviously for those of us who haven't been dealing very much with this short-term business visitor and then independent professional route, those two, you know, they seem to be very fixed categories in as a matter of immigration law, and it was very helpful for your clarification. And I gather you're also going to go on and tell those of us who have been fortunate to benefit from the withdrawal agreement what sort of rights that might give us over and above the TCA. Thanks very much, Adrian.
Great, thank you very much. I'm only going to deal with the outbound provisions of not dealing with immigration into the UK, because of course for us that's our major concern going into the EU. Hitherto, we've just of course had free movement. So whether we're going for short-term service provision or for longer term to establish ourselves as self-employed and to get both authorization to work and permission to reside, all of those things have been bundled up in free movement, and they're now unbundled and then put partly into the provisions of this agreement in terms of what we can and cannot do in terms of moving short term to supply services, and then partly they're going to be under the local law in each of the 27 EU states. So this treaty, the Trade and Cooperation Treaty, obviously deals with the EU. It doesn't deal with the other European Economic Area states such as Norway and Liechtenstein and Iceland, nor does it deal with the arrangement with Switzerland, which is subject to the UK-Swiss Mobility Agreement, which was published in December. What we need to know is how you go for short-term visits and what rules apply, what you can do, and if you want to go on a more enduring basis, but still on a temporary basis, how does that work? The Trade and Cooperation Treaty has two routes of interest to us. One is the short-term business visitor route, and one is the independent professional visitor route. As short-term business visitors, there's a route which in some senses doesn't really add very much for our purposes. The key aspects to it are that we need to know is that you can only go for 90 days in any 6-month period. The category is visa-free, so you can jump on a plane and go. You don't have to get a visa prior to getting on the plane. There are no carrier's liability penalties for carrying you to your destination. But the main downside to it is whatever you do, you can't take a fee from the client in the host state. So you can't travel in order to do paid work and get paid from a client in the host state. You mustn't be engaged in selling goods or services, in our case, of course, to the public, or receive remuneration from within the party where you're staying temporarily. So it's not that much, it doesn't have that much interest to us in terms of a remunerative income, in terms of a remunerative profession. But there are some things that are listed that you can do. And they include not only meetings and consultations, but training seminars, what's called trade fairs and exhibitions, but that might include conferences, which are essentially disguised marketing opportunities, sales. You can go travel to agree to provide services, but not supply the services themselves, and so on and so forth. So it's not completely useless, but it is limited to things which are essentially prior to engaging in economic activity. Even within that envelope, there are somewhat so-called non-conforming measures where you might still require a permit or a work permit in some countries, and there's a list of those which will be in the paper which I've prepared and which will be circulating afterwards. So you have to look out for that. The UK originally, in its draft of the treaty, wanted to secure the ability for business visitors to take a fee from a client, what we in the UK call permitted paid engagements, but that didn't end up in the final agreement. So within that narrow range, only certain things you can do, essentially uneconomic activity or pre-economic activity, which might involve marketing, might involve meetings, might involve some self-promotion. It's not brilliant. And of course, there was already Schengen visitor rules for business visitors. So the Schengen area is not coterminous with the European Union. Not all European Union states participate in it. For example, Denmark doesn't. And some European Economic Area countries that are not in the EU do participate in the Schengen area, but it basically provides an area without internal borders. And within that area, third country nationals, which of course UK nationals now are, could get Schengen visitor entry. And UK nationals are non-visa nationals, so they don't have to apply for a visa for a Schengen visa to enter as Schengen visitors. And that already has provision for Schengen business visitors effectively. And again, they didn't anticipate under the Schengen business visitor rule having entry to take a fee from a client in the host state. In other words, you could go as a business visitor for meetings and the like, but you couldn't travel to do economic activity. And the Schengen limit on how long you could go for was 180 days in any 6 months. And here, of course, 90 days, in any 6-month period. And of course, under the business visitor rule, under the Trade and Cooperation Treaty, it's effectively the same period. So there's no real gain under the treaty, the Trade and Cooperation Treaty, from the Schengen business visitor rules. You'd be a non-visa national under both, and you're only really able to stay for 90 days in any 6-month period under both. So nothing really changes for us under that route. You can't take a fee. The more interesting route is independent professionals, which is separately constituted. You mustn't be established in the territory which you're travelling to. You must have a proper contract, at least 6 years professional experience. And then there is a provision for you to enter as an independent professional, a self-employed person, to go and provide services for a fee. It doesn't allow you to use the professional title of the host state where you are. The route itself can't be made subject to restrictions on the total number of independent professionals entering any particular state or subject to an economic needs test. What can be done is a visa requirement can be imposed. So unlike your French or German counterpart who might be traveling to Italy to supply services as an independent professional, you will need to potentially get a visa prior to travel. And that's where you're going to have to check with the individual EU state concerned, because there's latitude under the Trade and Cooperation Treaty to for each individual EU state to insist upon visas if it should choose to do so for this route. We're going to have to see whether it does in fact require you to obtain a visa prior to travel, or whether the state in question simply allows you to present your credentials on entry at the border on arrival and seek entry as an independent professional. States which are competitively minded will seek to allow people from the UK, no doubt, to travel visa-free and be admitted as independent professionals on arrival. Other states that don't have a competitive turn of attitude towards this will impose visa requirements. The only things which you can do, though, are legal advisory services in respect of public international law and home jurisdiction law. So this route, this mobility route, only allows you to provide legal advisory services, and then only in respect of PIL, public international law, and home jurisdiction law. If you want to travel to provide advocacy services, whether in a court or tribunal or an arbitration, or in an arbitration, you're going to need to apply for a visa or for entry under the local rules of the individual state concerned. Even within the IP route, there are also some reservations. A couple of countries, I think it's Austria and the Czech Republic, have reservations in respect of the period of time for which you can go there, and in respect of legal advisory services, which all are allowed to apply. About half the countries, and again, the full list is in the paper, which I'm going to circulate, has an economic needs test which is applied. So you have to be very careful with this route. It's useful for some things, for providing home state advice or public international law advice, not EU law advice. If you want to do advocacy, or you want to stay there beyond 12 months, you're going to be there under local rules. I've said that there are two things that you need. One thing you need to check if you don't qualify for the independent professional route. You have to go under local immigration rules in the state concerned and check them. Of course, if you're seeking to go and represent someone before an international court or tribunal that's constituted under an international treaty, then you may have the right of entry to appear in front of that court, like the Court of Justice in Luxembourg or the ICJ in The Hague, under the international treaty governing it, or the statute that governs the operation of that court. That may contain a right of entry for people who are representing parties before it, to appear before it. So if you don't come under the independent professional route for advocacy, as you won't, because it only applies for legal advice, then check not just the local rules of the state concerned, but if you're appearing before an international court, whether or not the treaty arrangements for that court allow you to travel to that state to appear in front of it, because then you'll be able to travel or get a visa to travel to appear in front of that court. So if you want to stay beyond 12 months as an independent professional, you're going to be under local rules in any event. In respect of, so for longer visits, then you have to look at the individual immigration rules of each country. Similarly, if you want to establish yourselves as an actor self-employed on an enduring basis in an EU state, and you want to be lawfully resident there, you're going to have to look to the individual inbound immigration rules of the country concerned. So France has provisions for liberal professionals, for the liberal people who are engaged in liberal professions to enter and reside there. You're going to have to look to France's rules if you want to appear there as an advocate in Paris. One thing that is worth pointing out, separately from the Trade and Cooperation Agreement, are the frontier worker provisions in the Withdrawal Agreement, which of course has already been transposed into the laws of the and is operative in the laws of the UK and of the EU member states. The reason I mention that is because for those of you who've been lucky enough to be providing services prior to the end of the transition period at 11 p.m. last New Year's Eve, you'll be able to use frontier worker provisions if you're continuing to work there. So you mustn't be established in the state in which you're providing the services and traveling to it as a frontier worker. Your residence must be the UK, but then you're allowed to travel to your state of work back and forth, even as a self-employed person, not just as an employed person. You're still a frontier worker under the frontier worker provisions in the Withdrawal Agreement. And there are four criteria which apply for you to fall within the scope of this. You must have pursued economic activity prior to the end of the transition period, but there's no minimum period of time specified for its exercise. You must have done it in accordance with EU law, so there can't have been any abuse of rights. And having done it before the end of the transition period, you must continue to be economically active thereafter in one or more EU states. So if you're travelling back and forth to provide services in the EU and you've done it before the end of the transition period, you will fall within the scope of the withdrawal agreement and have frontier worker rights as a self-employed person. Not only will that allow you to travel and work there, but curiously enough, your family members can reside in the state of work if that's convenient to them. They have rights under the withdrawal agreement too, and you have rights to equal treatment in respect of social advantages in the state of work. So that can be useful. One really good point to note is if you're temporarily ill or lacking in work, you still have continuity of self-employment rights as a frontier worker in the country or countries in which you've been travelling to work. And the particularly useful thing from an immigration perspective when you're travelling back and forth is that if the country in question requires you to hold a document certifying that you're a frontier worker, then you're entitled to hold one, and one must be issued to you by the country in which you're travelling to work. So unlike having to get a visa where you have to get permission from the country in question, effectively you can demand from the country in question as of your right this document, and that will enable you to travel back and forth for so long as you continue to be a frontier worker. So that's an extremely useful provision for those that are already supplying services to within one or more EU states prior to the end of the transition period and are continuing to do so now. And it gets you out of the problem of, well, I can't supply services as a short-term business visitor for a fee under the withdrawal agreement, under the trade and cooperation agreement, nor can I do so under the Schengen business visitor rules. But I've still got this frontier worker provision, which is really, really good, and I can use that because I'm already doing it. If you're newly taking up practice service provision in the EU from 2021 onwards, then you're going to have to satisfy either, and you're providing services and taking a fee from a client in an EU state, then you either have to satisfy the local rules of the EU state in question, or under some international treaty arrangement if you're appearing before an international court, or you have to get independent professional route admission using the IP route. Two final points to note briefly before we take questions. As far as practice in the Republic of Ireland is concerned, the UK and Ireland, of course, have common travel area arrangements between them, which they've had ever since Ireland seceded from the UK in 1922. And under current arrangements, British citizens and other qualifying UK nationals are permitted to live and reside and work in Ireland without any immigration restrictions on their ability to enter and reside, and without any immigration restrictions on or conditions on their ability to work there. Of course, there will be local bar provisions which are not in subject of today's presentation, which have to be satisfied. So the common travel area is quite separate. It's bilateral. It's not within the scope of any EU law provisions, and so Ireland remains effectively a jurisdiction where you can base yourself and undertake self-employed services as a self-employed barrister. One final point to note, which is important, which we've never really had to think about, it's always in the background for people who move, whether temporarily or on a more enduring basis, to reside. It's about the coordination of social security, healthcare and pensions requirements. That was previously part of EU law and continues to be so for those that fall within the scope of the withdrawal agreement. If you're working temporarily for up to a year, as you could be as an independent professional in another EU state or in an EU state, you would still be paying your national insurance contributions in the UK under the Protocol on Social Security Coordination in the Trade and Cooperation Treaty. But you'll be able to, to claim public health care benefit in kind in the country in which you're working and staying in temporarily, and also, if it mattered and if you qualified for it under the rules of general application, any cash benefits. And so the national insurance contributions that you continue to pay in the UK will cover you for social security, healthcare, and building up your pension, even if you're working temporarily in the EU under the IP route from 2021 onwards, and there are equivalent provisions under the withdrawal agreement for those who have frontier worker coverage. So that's a very quick tour. I've got a paper which sets this all out in much more detail, and which will be available to you shortly. Hugh, thank you. Back to you.
Well, thanks very much indeed, Adrian. That's a great summary. So I think there we pass over. I've been jotting down various questions as they've come into the chat. The first one is on one of the points I made in the introduction. about, I mentioned international law. Of course, that means public international law. And so that doesn't include, for example, international arbitration and arbitration. I mean, the point about arbitration, I can just cover it briefly here. It's not really the subject of our seminar. The TCA, the first point to make is that the TCA says what must happen, but doesn't actually explain to you what member state law actually provides for. So if you're an arbitration centre like France, you wouldn't expect France to be objecting to counsel coming across to provide arbitration services, but we need to find out what the position is. The TCA says was what must happen. The second point is that arbitration was regarded traditionally as a form of management consultancy and not legal services, because you didn't need to be legally qualified to engage in arbitration. At a very late stage, the issue of arbitration and whether arbitration should be included within legal services was raised by the EU. I mean, I think that was really a matter of a few days and weeks rather than months before the end of the negotiations. And so the result is that on page 114 of the agreement, there is a reference there to a definition of legal services, and one part of the definition includes legal arbitration, but it says, but excluding such services when supplied by natural persons as set out in Servin 4.1. Servin 4.1 is back on page 86. And the way the MOJ sees this, and we haven't yet bottomed it out, but the way the MOJ sees it is that 4.11, this is a chapter applicable to entry and temporary stay of natural persons for business purposes, i.e. fly in, fly out. And so although 5.48 includes legal arbitration services within the definition of legal services, the MOJ's view at the moment anyway is that because the definition of legal services expressly excludes Servin 4.1 and Servin 4.1 is concerned with fly in, fly out, then you remain free to provide arbitration representation services in other states as a matter of the provision of services. Obviously, Adrian's touched on the issue of, or more than touched, he was describing the point about whether you need a visa, and it seems quite possible that you will need a visa if you are providing advocacy services within a country which requires that in order to provide such services. So that was the first point. I think if I could start off, Adrian, actually, or maybe our government colleagues, just the UK-Swiss agreement. Can you give us a thumbnail sketch of that agreement? Because obviously, if you're talking about international arbitration, then Geneva and Zurich are very important for the provision of arbitration services. Adrian, is that fair, or is that you're on mute? You're on mute, Adrian.
I was just waiting to see if. All right, can you hear me now? Yep. I was just waiting to see if anyone from government wanted to jump in first. I mean, the UK-Swiss agreement is not mutual in the sense it's not reciprocal. In terms of there is a more open attitude towards the provision of services in the mobility sense under the Swiss agreement. It's not limited in the way that the trade and cooperation agreement is with the EU. So there is a more generous approach going to Switzerland to provide services in mobility terms. It's not reciprocated the other way. The UK still applies its own requirements to have entry clearance and a visa coming back if you're coming to do an arbitration in the UK. So Switzerland, if there is a question of going to Switzerland, it's going to be the mobility provisions are more generous to go to Switzerland than they are to EU states under the UK-Swiss mobility agreement. The Swiss seem to have an appetite for encouraging UK professionals to go there and undertake service provision. It's limited, time limited, for up to 90 days, I think, but it is pretty generous in comparison to what we see in the trade and cooperation agreement.
Yeah. Okay. Great. So, in fact, I just see a question come off the chat. You mentioned Republic of Ireland, and one of the other questions related to that too. So, are we permitted to represent clients in arbitration matters or IP matters without gaining any permission without seeking visas? Adrian, just in the Republic of Ireland.
Yeah, I mean, the question of, in a regulatory sense, under Irish arbitration law, whether you're allowed to act is separate from the question of whether you require immigration permission to do so. You do not require immigration permission to work in Ireland, whatever the work is that you're doing. But if arbitration in Ireland is limited to certain classes of persons under Irish law, in a regulatory sense, that would be a different question. So I don't know, I'm not a regulatory lawyer, but in terms of immigration law, you don't need immigration permission to work in Ireland to do arbitrations. If the Irish regulate arbitrations, then they will have their own rules that apply in a regulatory sense, not in the immigration sense.
Right. Yeah. So sorry, do we want Sam, do you want to come in on that?
Yeah, no, I just want to say, like, I broadly agree with Adrian's characterisation. I think there are two separate questions here. I think we can very confidently say in a base position, government's maintaining the common travel area. You have the right to work and live in Ireland, but obviously the right to perform certain legal services is separate, and that's something that on the base side anyway we wouldn't be able to comment on. So it'd either be one for MOJ to pick up or we take it away. Well, I mean, Bays being us, being mobility people. Yeah.
Yeah. Okay. Great. And I just saw somebody put up their hand. Chloe put up her hand. If you could if Chloe could put her question into the chat, then we'll try and get to it. So
terribly.
And then
my chat's been disabled. That's the only reason I put up my hand.
Okay. But if we could just the short-term business visitor. I think there was a bit of a difference, I thought, between the PowerPoint and what Adrian said, because in the PowerPoint, in the red writing in the PowerPoint, it was, can I go to see a client in Paris? I'm paraphrasing because I haven't got it in front of me. Can I go to see a client in Paris? Yes, you can, provided you don't take payment whilst you're there. But I think Adrian, you were saying really that if you're going to see a client and you're going to be charging that client for that, then you couldn't use the short-term business visitor route, whereas possibly if you're going to a conference and you meet somebody who might become a client, and then you perhaps go back with a bit more promotional work specifically to make a pitch or something, that there you wouldn't be taking a fee. Well, can you give us any clarity, perhaps? I don't know, Sam and Adrian, about that?
In terms of how, for example, Schengen business visitor rules have worked, which is we sort of have a template for this because the Schengen business visitor rules have been in place for some time into the Schengen area. You're not supposed to engage in economic activity. You're not supposed to take a fee. And the equivalent rule in the trade and cooperation agreement is designed to stop you precisely doing that. It's a sleight of hand to some extent to then just collect the fee once you've provided the activity, once you leave the jurisdiction. Whether or not it's tolerated in practice is a different question. And anyone who's ever worked in the area of business visitor rules will know that sometimes a blind eye is taken in practical terms to short-term business visitors who often do a whole range of things, which if the rules were applied to the letter, might be considered objectionable by the immigration authorities. My concern is not to stretch them beyond their meaning in terms of what their legal meaning is. What happens in practice may be more on a don't ask, don't tell basis. But I don't see. It seems to me that if you do the activity in the country in question, you end up collecting a fee from that client in the country in question, because just by simply avoiding it, by waiting till you go back, it might be abusive practice, and it could end up to you being banned from the country in question. Ultimately, some countries which take a dim view of that can exclude people from providing further services, and that would be a difficult thing. Whether countries do that or not remains to be seen, but I wouldn't want to say that a workaround like that was necessarily a sort of a wise idea for a lawyer to engage in.
No. I don't know whether, Sam, you want to add anything on that?
Yeah, and I think that is also touching on the right sort of area, which is, the TCA puts certain guarantees in place. Those guarantees are intended for non-paid business visitor activities in this sense. So, whether, if a country was going to allow, paid business visitor activities, there's nothing to stop a country doing that. There's nothing to stop a country not checking or not minding, but they may very well mind. And I think, I'm not a Home Office official, but I don't think the Home Office would take a positive view of people doing the same. For our immigration system, we do have paid permissive visitor activities to specifically cater for this. So yeah, that sort of route behaviour would not be covered within the deal and would be subject to how it's treated or viewed in the specific country.
Can I mention one thing very briefly? It was in the original UK draft to have permitted paid engagement as an idea, and it wasn't in the original EU draft. And so its omission in the agreed text is striking. The UK proposal did not prevail for a permitted paid engagement route, which is something, maybe some way of help guide to looking at what has been agreed and understanding it more precisely.
And just related to that, there was a question relating to whether a general counsel of a company, so a corporate lawyer, could travel to other business locations of their business. So I suppose you've got somebody like, I don't know, general counsel to EasyJet or Ryanair or something like that, who travels to another jurisdiction to, I don't know, maybe attend a board meeting or meet some colleagues in another country. Is that going to be treated, is that a short-term business visitor occupation, or is that something more?
That may well be short-term business visitor, because it's not it's a sort of very brief intercorporate transfer in a sense. You're going from one entity to another, which are linked. It's not a contractual service supply to a final consumer, so it's not something like that. But that's so you're not selling something you're not providing a service to a final consumer, and so you're not necessarily taking a fee from a customer, if you like. And on that sense, it's more likely to come within the short-term business visitor route. So what we're looking for is to see how these rules are embraced in the domestic visitor rules of the countries concerned, because here, of course, they're refracted through the UK visitor rules, and with the IP route, they're embraced in the immigration rules. And we'll be looking for the equivalent transposition and implementation and accompanying guidance in each individual EU state. We're going to have to get a little library together of all the busy ones, that we're going to see how that works. So it remains, where there are grey areas, it's their interpretation which is going to matter in the first instance, in the state in question.
Yeah, and again, we stress that the way an FTA works is that the FTA is setting out what the EU member states, so the TCA is setting out what EU member states. But of course, I mean, for example, free advocates coming in to provide arbitration services. If you seriously rate yourself as an arbitration centre and you're raising barriers, then it's going to be more difficult to be a credible arbitration centre. And that's in fact possibly one of the problems with our own approach to immigration, that if we're too strict on that, then it will have an adverse effect on the ability of the UK to compete as an arbitration centre going forward. Okay, one of the questions also asked whether the same rules apply to EU lawyers. I think obviously Sam and Zoe, they covered that up to a point in the last couple of slides with the incoming rules. But I don't know whether, and I think Adrian, you haven't really covered that in your presentation for reasons you explained. Any brief comments on that point?
Yes, I mean, they do apply. I mean, it is a reciprocal treaty, unlike the and on an inbound basis, coming into the UK as an independent professional, you're required to get both a sponsor, the person, UK sponsor to whom you are providing the service, and also to apply for a visa prior to travel. So both of those things are open to the UK to impose under the treaty, and they have taken the option of doing that. So there is a route. Of course, you have to get prior permission before boarding the plane. In terms of short-term business visitors, I think one category of permitted non-economic activity has been added to the list for general we already had obviously a developed visitor rule to the general activities list that business visitors can provide. I mean, our rule is that you can come for 6 months in 12, and so the treaty really adds little to that. It doesn't add anything to that. So there's a tiny tweak to it, but the visitor rule essentially that we have already had continues to supply 95% of the answer.
Yes. And one of the other questioners, I'm sorry, Sam, did you want to add to that? No?
Yeah, I mean, I think it's worth saying that obviously there's a fairly balanced set of obligations on both sides as a result of the TCA. But obviously, as we touched on before, countries have the different immigration systems regardless. So coming to the UK as an EU business visitor, you're going to be subject to the UK's immigration system, which is not going to be the exact same as others. And I think it's the view we have here that ours is fairly liberal in some respects and does allow for some paid permitted engagements, including in the legal space. So EU business travellers coming to the UK might be able to benefit from that, whereas that same route might not apply in every EU country going the other way. So then, there are slight differences to be aware of, I would say.
Okay, so and I think we've just got about 5 minutes left. We've still got some a few questions. What about if an EU national wants to come and do pupillage in the UK and requalify here? Is that something that they can feasibly do under one of these routes? I suppose the problem would be they'd be spending too much time in the UK, so they'd need to go along a special route. Either of you?
You can't come under the trade and cooperation agreement to do pupillage because you have to have 6, as an IP independent professional, you have to be qualified for 6 years to do that. And it's not under the short-term business visitor route. There is a temporary route under T5, so-called Tier 5 of the UK immigration rules, where the Bar Council has a sponsor license to enable people to come and do pupillage in chambers, which applied to third country nationals from outside the EU prior to the end of the Brexit transition period, and which now EU citizens will have to make use of if they want to come to the UK to do pupillage. It's an established route that now applies to them as well as to people from the rest of the world.
Right. So more work, I suspect, for the International Committee of or rather desk officers. Okay, so further question. I mean, this 90 days and 6 months. It's just I was just wondering about practically, in practice, how that works, when it starts, when it ends. So could you, can you deem because if you want to work, say if you take a calendar year, if you say, well, I'm going to work in the UK for January to March, then I'll work in France from end of March until June, and then in July, well, in fact, I'd like to do my next 90 days in France, starting in July for the next 3 months until September, and then the last section of the year you then spend in the UK. Now, how does it work?
Well, from the UK's perspective, the rule which is being applied is the same as it ever was. That it's 6 months in any 12-month period, and if you stay beyond that, it's considered that you're really here as a resident, and therefore you're not intending to leave, and therefore you're breaching immigration conditions on entry or by remaining here. So, and that can lead to you being red flagged and make it very difficult for you to re-enter the UK in the future. So the UK hasn't changed its stance in its immigration rules on the permitted time that you're to be here, because in a sense the 90 days in a 3-month period just gets wrapped up inside what the UK provision was in any event.
Okay. So, and then one of the questions asked about services across borders. In practice, the regulatory aspects of that are covered by English law, and there's nothing under English law to prevent you doing that. The question is that there is a further question, and that's still being debated within the various discussions ongoing. There is some attempt to regulate that under the TCA, I think, but I mean, personally, I see that it's quite difficult to regulate that. I don't know whether anyone on the call, anyone of the speakers has a comment on the position for Mode 1 provision.
So, I mean, Mode 1 is covered in the agreement. It's not our section, as you touched on. If a specific response is required to that, we'll go to our colleagues who handle that and get back. Yeah, as I said, it's cross-border trading services and different rules apply.
Yeah. Okay. So, and then there was, I think, the final question I've got so far on my list, and this is quite good timing because it's just coming up at 6 o'clock. So, if you've got dual nationality, can you use, that's dual UK, say French nationality, can you use your EU passport to enter and provide services as a barrister in France without worrying about visas and things?
If you're a French national going to France, you enter as a French national, so there's no problem. It's if you're in your own country of nationality, then you're able to work and enter and come and go without restrictions. So there's no issue. So a dual UK EU national is fine in both. They're doing it under their own law. They're not doing it. You're a Brit in Britain and a French person in France, so to speak.
Sure. But what happens if there's a Brit sort of Anglo-French national wanting to do an arbitration in Germany, and so there you'd be relying in terms of provision of services on your EU right to provide services around the different EU states. So you'd be relying on your French nationality. Can you do that? Can you go to Germany and provide and do your arbitration without seeking a visa from the Germans?
Oh yes, yes, because it's free movement. You're a French, you're an EU citizen moving across an intra-EU border to provide services. No problem with that at all. And in fact, you'd still be a French citizen doing that, even if you entered Germany on your UK passport. It wouldn't make any difference. You just got the right to do that.
Yeah, because it is nationality which grants you the access to the four freedoms.
Exactly.
Under EU law.
Yeah.
Okay, and thanks very much indeed to Christian Visciokum from the Bar Council, who's been providing fantastic service over the last year in trying to help us navigate all this. He says that Mode 1 supply of UK and public international law is permitted in the TCA, but there's some doubt about EU law because the EU was trying to block off UK qualified lawyers from providing any EU law services. And I see also in relation to Germany, my example of Germany, temporary supply of legal services is not permitted in Germany. You need to establish, unless of course you are an EU national, whereupon you're seeking the benefit of your EU law rights under the Freedom of Pride Services, which is the EU law equivalent of fly in, fly out. Okay, so I think we've therefore dealt with all the questions. As I said earlier, there's going to be a slightly tweaked version of the PowerPoint, which will be circulated during the course of next week by Claudia from the Bar Council. And also there will be a note from Adrian. We're just sort of wanting to check them over as they've both been produced in double quick time in order to ensure that this seminar could go ahead. And we've touched in the seminar on some of the professional the professional qualifications aspects. I should tip you off that there is a further seminar on the 28th of January this year, put on by the European Circuit of the Bar. That's europeancircuit.com if you want to look it up. And that will have a Belgian lawyer, an Irish lawyer, a French lawyer, and again, I'm chairing, I'm afraid, talking about the professional services aspects and the results of the trade deal and more generally discussing those professional service aspects. So I think it remains really, I think, to thank all the speakers very warmly. So to thank Sam and Kiri and Zoe from government departments for their intervention in the seminar. Thanks very much indeed for coming along. And thank you all very much indeed, Adrian, as always, as our stalwart, our go-to person on immigration and what you can and can't do in going abroad. So I think that if one person's practice is going to boom as a result of this, as a result of the new arrangements, one hopes it's going to be Adrian's. Very good. So thank you very much indeed, everybody. And if you join the seminar, you should really, if you're a barrister or a lawyer, you should really join the European Circuit and follow the events of the circuits going forward, as we'll try to cover some of the areas of interest. Thanks very much, everyone, and have a good evening.